Now calling civil case 23-5523, unknown party versus Google LLC et al. Will counsel please state your appearances for the record, starting with the plaintiff?
Good afternoon, Your Honor. Lisa Haba for the plaintiff.
Good afternoon, Your Honor. Margaret Maybe for the plaintiff as well.
Hi.
Good afternoon, Your Honor. Amit Gressel for defendants Google and YouTube.
Hi.
Good afternoon, Your Honor. This is Brian Willen, also for the Google and YouTube defendants.
Good afternoon, Your Honor. I am James Jackson.
Good afternoon, Your Honor. I am.
Okay.
So today was the very first day of court between Jackson versus Sarah versus Regina versus Google. And it was very, very underwhelming. However, there is some interesting things that happen in here, and I have condensed the video even further down to what it was. I've taken out a lot of the pauses and a lot of the big no talking sequences, so you can get right to directly to the point here. Essentially, what happens in this is the judge chews everybody out. That's the simplest way I can express this. Legally, everybody kind of screwed themselves up in a way, even Onision. The judge goes at everybody here for a procedural issue because things were not done properly in the court system with two separate cases in two different states. And there was an issue of consolidation of where cases that are both related need to be combined into one and then sent over to, I guess there was two different judges in two different states dealing with two different cases. But this overall, the judge does explain this pretty clear cut on what everybody kind of did wrong in this situation. It is kind of frustrating to see Onision kind of smirk and try to bite his lip, try not to laugh because all the lawyers kind of screwed themselves in this. Not in a major way. Like, it's not going to be like life-changing. Like, the case isn't just going to just go away because they messed up in these minor things. But it is, things weren't done properly. And in the legal system, you have to do things in this very, very delicately. And you have to do things in a specific pathway in order to achieve things legally by the book. And this judge that we have here is a by-the-book judge, and that's not necessarily a bad thing. So here it is in its entirety. I requested this. I was at work all day, so I didn't get to see this live. I've blurred all the names just for prosperity's sake, for privacy, even though this is a publicly available court case that is ongoing. So this is all public record, so if you want to file a privacy complaint on me, Onision, for posting this, by all means, go ahead. It shouldn't go through. But yeah, so yeah.
Mr. I'll call you Lucas Jackson to distinguish you from James Jackson. You were cutting in and out, so we didn't hear you. You want to try to make your appearance again?
Yeah. Good afternoon, Your Honor. I am Lucas Jackson, also pro se.
Afternoon. Okay, so as you all know from the order I issued, I'm in sort of a state of confusion about the procedural status of this case, and that's what I want to limit our discussion to today. So let me make sure I understand the timeline here, the procedural timeline. So Gina filed a case in Florida, is that right?
That's correct, Your Honor.
Okay, so that's the first thing that happened in federal court, at least?
Yes.
Okay, Regina files a federal case in Florida against the Jacksons.
It was against the Jacksons and against the YouTube defendants.
So it's Regina versus Jacksons, and I'll just call them Google, in Florida. And then
Yes, Your Honor.
Sarah files a lawsuit in federal court in Michigan.
Correct. The Western District.
Okay. Against
The same parties.
Jacksons and YouTube, Jacksons and Google, all right, in Michigan. And then the Florida case gets transferred to the Northern District of California, right?
That's correct. Yes.
And then sometime after that, the Sarah's case from Michigan gets transferred to the Northern District of California, right?
Yes, correct.
And the Regina's case that came from Florida got assigned to Judge Donato.
Yes.
And Sarah's case that came from Michigan got assigned to me.
Correct.
Okay. And then did anybody file a notice of related case in either of these cases?
We have prepared one. It has not been filed yet. We're having a lot of trouble getting in touch with counsel representing the Jacksons. We've attempted.
Well, wait a minute. Hold on a second. You don't need to you don't need to be in touch with counsel representing the Jacksons to file a notice of related case. I mean, the point of filing a notice of related case is to notify the court that there are two judges with similar or identical cases, right? To allow them to consider whether the cases should be adjudicated by the same judge. So when did the Regina case arrive from Florida to the Northern District of California?
One moment. It was transferred in October of 2023.
Okay, so and when did the Sarah case arrive from Michigan and end up in my court?
It would have been around the same time, but I'll confirm for you. October of 2023, Your Honor.
And so these two cases have been sitting in our court for a year, and nobody has notified us of the two related cases that are here in our
Well,
court.
it's not that simple, Your Honor. In relation to the Jacksons, they filed a suggestion of bankruptcy almost immediately upon it arriving in California. Their cases have been in automatic stay until around May of this year. I believe there's a notice in June when that stay was lifted. Meanwhile, in January of 2024, YouTube, the Google defendants and plaintiffs got together. We agreed to dismiss the claims in the Donato case and file all of those claims before Your Honor. So we filed an amended complaint, which is what has been fully briefed before this court and was initially set for today's motion to dismiss. So as it pertains to the YouTube defendants, we collectively did that together. When the stay was lifted after May in the Donato courtroom, the Jackson defendants have counsel in that case. They don't have counsel in this case. Counsel for that case emailed myself and Miss Baby and asked us if we would intended to consolidate the cases, to which we evaluated that, agreed that that was something that we should do. And it appeared based on the communications with opposing counsel that was an agreed position. We sent him a motion to accomplish that.
Hold
We've
on.
gone back.
I have to interrupt you for a second, because when you have, and I'm going to especially want to hear from Google's counsel in a second, when you have two cases against all the same defendants, asserting basically the same claims in two different courtrooms, you let the judges know. You file a notice of related case. You notify the judges that this is going on so that the judges can figure out how best to utilize judicial resources in the adjudication of these cases. And if you had done that, the very moment you had done that, I'm sure that the cases would have been related, right? And by the way, let me ask you one other question. The case that's in front of me, right, that came from Michigan, was it just Sarah who filed the lawsuit in that case, or was it Sarah and Regina who filed the lawsuit in the Michigan case?
It was just Sarah.
But Regina is a plaintiff now, right?
She is now pertaining to the YouTube defendant.
In this case.
Yes.
Okay, so that happened when you reached the agreement with the YouTube defendants to drop them from the Donato case and pursue the claims in this case?
Yes, Your Honor.
Okay. That sounds a little bit like judge shopping, right? You have an earlier filed case, and then a later filed case, and you drop the defendants from the earlier filed case and pursue the claims in the later filed case. Why did you drop the YouTube defendants from the earlier filed case and just pursue the claims in the later filed case?
I don't think any of the, I don't want to speak for Google, but just based on our communications, I don't think any of us were intending to judge shop. We felt that was how we would best proceed. Part of it was based on the fact that the Jacksons, we knew they would be eventually arriving as part of the cases when the bankruptcy situation was concluded. They didn't have representation in the case before Your Honor. They did have representation before the case involving Judge Donato, but we also understood that attorney may or may not be withdrawing, and we weren't really entirely clear on what the status of that was. It seemed
What
a
does
little
that
bit
have
murkier.
what does that have to do with anything?
As mentioned, we've had trouble communicating with him.
What does that have to do with the choice of whether to proceed in the earlier filed case before Donato versus the later filed case before me? I don't understand. I mean, if it wasn't judge shopping, like what was the reason to proceed in the later filed case against Google?
I'm sorry, Judge, my internet is cutting out. We're in the middle of a hurricane right now. I'm located in Florida, so I'm so sorry. My thing is cutting out. I didn't hear the
Your
last.
Honor, I'm going to speak to answer on behalf of my co-counsel while she's able to get back on through the hurricane. And I will note that Your Honor had put a case management conference together, and we had moved this case forward. And I believe the goal by all of the parties involved was for efficiency of judicial resources, because this case had been moving forward, for us to go where the case had actually been. And we would have dismissed the Donato action had we been able to do so, but there was a bankruptcy stay, so we were not able to complete that. And it was, in my understanding, an effort to move to the court in which these cases were progressing, because it had been so extremely long since the first filing date, for us to move to the case where Your Honor had already heard our motions.
Are you saying that you can't voluntarily dismiss a case that is subject to a bankruptcy stay?
We could not voluntarily dismiss because we didn't want to dismiss the case entirely. We wanted to just consolidate. And because the Jacksons were in bankruptcy, we were unable, and they did not agree to consolidate over to the case before Your Honor.
So now the situation is that in this case, we have Sarah and Regina versus the Jacksons and the YouTube defendants.
Unfortunately, Your Honor, I wish that were the case. At this current moment, it is Sarah and Regina versus the Google defendants, and then all we have is Regina versus the Jacksons. And unfortunately, the Donato case has Sarah versus the Jacksons. And this would have never occurred had there not been a bankruptcy stay, but unfortunately we were unable to move forward based on those restraints.
But I still don't understand how we could have gone a year without the judges in these cases receiving a notification that there was a related case in the court in front of another judge. I still don't understand that. I don't understand what possible explanation there could be for not notifying us immediately when these two very, very similar cases were assigned to two different judges in the district. I mean, you have an obligation under the rules to notify us when that happens, right? And I can't imagine that we would still have two separate cases if you had notified us. So it seems like, this is a real, kind of procedural irregularity that we're dealing with here. And I'm trying to figure out how to solve it.
Your Honor, we are prepared to file the administrative motion. I apologize. We were under the impression we had to meet and confer. Understanding what Your Honor has said about that, we are prepared to file it today.
But the administrative motion, you file it in the earlier filed case, right?
Correct.
And you ask the judge in the earlier filed case whether they believe they will relate the two cases. So the result of an administrative motion to consider whether the cases are related would be to have Judge Donato deciding whether this case should go over to him, right? And that, candidly, that's probably what should have happened when these two cases came in a year ago, right? I mean, and then obviously Judge Donato can make his own decision about whether they are related within the meaning of the local rules. But it seems to me that that's the very first thing that should have happened in this case when the Regina case got to Donato, the Sarah case gets to me, and like the first thing everybody does is file a related case notice, and then Judge Donato could have decided whether to relate the Sarah case over to him so that the two cases could be considered together. And then you could have had a discussion with Judge Donato about whether the cases should be consolidated.
I apologize, Your Honor, and we did file a notice of related action in the original Florida matter in Regina, and I believe this may be an error on our end, having previously filed the notice of related action, believing that we had done so and unsuccessfully not doing that.
Okay, and then, so now you filed a motion to consolidate the cases?
We have,
Okay, and you filed that with Judge Donato?
yes,
And so you're asking Judge Donato to consolidate his case with this case. And so that would mean that this case would be folded into Judge Donato's case and transferred to Judge Donato's docket and folded into his case?
I don't want to be unclear, just to be clear on the court record. In the motion, we asked that Donato's case be transferred into Your Honor's case because we felt there was more parties here and whatnot, and there was more that had moved forward in this case. So we felt.
But you filed it in Judge Donato? You filed it in front of Judge Donato? You're asking Judge Donato to send me a case?
To consolidate it into your case, Your Honor, yes.
That also is not the right way to go about it, right? I mean, the right thing to do is to get the cases related in front of the same judge, and then you can discuss with that judge whether the cases should be consolidated. But even if you didn't do that, I mean, even if they're in front of two judges, I can't imagine, I don't know for sure, but I can't imagine that it would be appropriate to file the motion to consolidate with the judge who you're trying to get rid of, right? For lack of a better word. I know that you're not trying to get rid of Judge Donato, but you're trying to get the cases consolidated in front of me. So if you're trying to get the cases consolidated in front of me, why wouldn't you file the motion to consolidate with me? I mean, what judge is going to say, all right, I'm just going to foist this case on my colleague because they filed a motion with me?
Our thought process, Your Honor, was that was the lower case number. So that was our understanding. I apologize if you misunderstood it. But I'd be happy to.
Right, but normally I would think if you're filing in the lower case number, you're asking for the later filed case to be consolidated into the earlier filed case, right? I mean, that's normally when a judge gets a motion to consolidate, the judge is being asked to fold another case into their existing case, right? The judge is not being asked to send their case over to another judge. So we're in sort of a procedural morass, it seems to me right now. And I don't know, I don't know what the best way to deal with it is. I mean, one solution is I haven't had a chance to talk to Judge Donato yet. I mean, I could talk to him about it and see what he thinks is appropriate. I mean, my initial sense is that the very first thing that should have happened is a notice of related case should have been filed with Judge Donato, and then he could decide whether the later filed case is related to his. If he says yes, then the later filed case goes to him. He's got both cases. Y'all can have a discussion about whether they can be consolidated. That's what should have happened at the outset. And I'm wondering if that is what should happen now. And then Judge Donato can decide, and of course he's perfectly free to make his own decision about that, but he can decide if he wants to relate the cases, he can, and then he can entertain the motion to consolidate that's been filed in his court in the Regina case. I think that's the appropriate way to handle this issue. I'm not, I'm happy to hear other suggestions, but that seems to me the appropriate way to deal with this procedural irregularity that we have here. I mean, did Google even know that you were filing a motion to consolidate the cases?
As it pertained to Google, we had talked to them, of course, when we agreed to consolidate their claims. As it pertained to the Jackson defendants' claims, no, we did not discuss it with Google because it didn't pertain to their claims ahead of time. We did attempt to speak to.
Well, but wait a minute. I mean, you filed a motion in front of Judge Donato to consolidate the two cases, and Google is currently involved in one of the two cases. So Google has to be put on notice of such a motion, right? When you're asking for another case to be consolidated into a case that a party is involved in, the party that's involved in that second case has to be notified notified of the motion to consolidate?
There was a conversation, I mean, to be candid, there was a conversation. We talked to Google's counsel extensively. I can't off the top of my head tell you the exact date, but it was prior to us drafting the motion. We had mentioned to Google's counsel that we intended to potentially file this motion. Their position at the time was this doesn't really pertain to us because Google's position at the time was that they felt that this was going to be handled at the motion to dismiss level. They believe that their case will be dismissed, of course, and of course we disagree, but that will be dealt with when we get to that substantive motion. But as a result of that, the position that was expressed to us was that doesn't really involve us. So it's not that we didn't ever discuss it with them at length. Did we send them a copy of the motion before it was filed? No, because it was being intended to be filed in the Donato case, of which they were no longer parties.
Okay. Was Google aware of this motion to consolidate?
Your Honor, if I may, I don't have a recollection of being told that there was a motion to consolidate coming, and I don't want to. There was some discussion earlier about us having gotten together with plaintiffs to sort out this procedural problem. That is how I would describe this. When both cases were transferred here from Florida and from Michigan, and there was a suggestion of bankruptcy, plaintiffs told us that they would like to dismiss the Alonzo claims and replead them in our case. And the only thing that they asked us is if we would stipulate to waive any statute of limitations issues. Our position was, okay, it's your case. You can plead the claims how you want. But it came about because we asked, are you going to consolidate or file a related case? I remember that conversation happening. And their answer was, we're going to dismiss Alonzo and bring them into this case. So I don't want to represent that we were fighting them tooth and nail. We weren't, but I also do not want it to be the record that we were somehow coordinating and strategizing how to put these all together. They said that this is the approach they wanted to take, and we didn't fight that because it's their case and they can plead it how they want.
Okay, but
I would motion to consolidate.
Didn't you also have an obligation to file a notice of related cases when the second case arrived and landed in my court?
Exactly, Your Honor. And notice in talking about that, that's when they said that they were going to dismiss the Alonzo claims against and bring them in. And so then the question for us was, is it still a related case if it's just the claims against the Jacksons from Alonzo against the Jacksons pending in Judge Donato's case? And I don't know that still meets the related
Why
case.
wouldn't it be? I mean, we have claims by I was using first names, and I don't have to use.
Sorry, yes, Regina and Sarah. So
if we have a claim by Regina against the Jacksons in one court and a claim by Regina against the Jacksons in another court, and they're the same claims, right? Where Regina's not yet in my case.
her claims against YouTube are in this case, not against Jackson.
Got it. So
everything against YouTube is here in this case. So there's nothing against YouTube pending in the Regina case.
I mean,
which is why we would.
It seemed, if you just take a step back for a moment and use common sense, right? The point of this rule is to alert judges when there are cases with a substantial overlap pending in front of two different judges of the same court, right? That is obviously the case here.
Yeah, I agree, Your Honor.
And Your Honor, just to speak to Mr. Grizel's comments there, it is not that plaintiffs did ever intended on not dismissing any of the claims against the Jacksons in that case. We didn't intend to consolidate them into one case, but the bankruptcy would prevent that because we were not allowed to file anything in the action given the stay.
Okay. Well, I don't think that I should have been adjudicating any motions in this case before a determination was made about whether the cases are related and should be in front of the same judge. So what I'm going to direct you to do is file a notice of related case in front of Judge Donato. And that way everybody will have an opportunity to express their view of whether the cases are related. And if you want to file a notice and say that you don't believe they're related, you can do that. I'm not sure how strong that argument would be, but you can take whatever position you want, but it's your job to put in front of him this issue of whether the two cases are related. And it should have been done a long time ago. And Google can take a position, and obviously the Jacksons can take a position. Now, this motion to consolidate that you filed, has anybody opposed that? I mean, Google, of course, didn't receive notice of it. Have the Jacksons opposed the motion?
Their attorney did indicate that they opposed it after he'd indicated he was asking us to do it, and then he indicated later that the Jacksons opposed it. They have not filed a responsive pleading or responsive motion, or response to the motion, rather.
Okay. And when is the motion to consolidate scheduled to be heard?
It's on
October 17th.
Thank you.
Yeah, and so the other thing that I think it was procedurally improper is I don't think it was proper to file a motion to consolidate in Judge Donato's case, asking him to fold his case into this case. And so but in any event, the first thing, so what I'm going to do is I'm going to deny Google's motion to dismiss as premature, I guess, because we need to sort out all this procedural stuff before I do any more adjudicating in this case. And I'm going to direct you to file a notice of related case in front of in Judge Donato's case by Monday. And then everybody, the Jacksons, will have an opportunity to respond to that, and Google will have an opportunity to respond to that. And I'm just going to tell you, and I'm sure I'll have a conversation with Judge Donato about this. I'm not sure, but I think that it's procedurally inappropriate to file a motion to consolidate in front of the judge whose case you're proposing will disappear. I think that you're supposed to file that in front of the judge whose case would be taking in the other case. Like I said, I'm not positive about that, but I think that must be the rule.
And Your Honor, since you're
And if I'm
denying,
right about that, you need to research that. And if I'm right about that, you need to fix that too, right? And it may be fixing it by just asking by saying we need to change our request. We're not asking that you send that you send your case to Chabria. We're asking that you consolidate Chabria's case into yours. And let me just say, I don't care. I'm happy to handle the case, but rules are rules, and the rules are there to ensure that that the case is adjudicated with procedural fairness. And this, it seems like we've sort of gone outside those boundaries, and we need to get ourselves back in before we do anything else in this case.
Your Honor, I know you made a ruling about the prematurity of the MTD involving Google. Did you want to is there a similar ruling as it pertains to the motion involving the Jackson defendants, or are we going to proceed on that?
No, we're not going to proceed on that. Another way to do it is to keep the motions. I don't want to, the Jacksons are pro se. I don't know. It's very confusing because they have a lawyer in the other case and they don't have a lawyer in this case. That doesn't make a lot of sense to me either. But they're pro se in this case. I don't really want to make them refile the motions. So why don't we say that the Google motion, let's scratch that. The Google motion is not denied. The Google motion will remain pending for now, and the Jackson motion will remain pending for now. And we'll sort out all this procedural business, and then we'll decide where to go from there. Okay, does anybody else have any comments or concerns?
Your Honor, I had a question about my counsel in the other case.
Okay.
Similar to the plaintiffs, I have had an enormous amount of difficulty communicating with said attorney due to just a non-responsiveness. I've requested repeatedly that that attorney withdraw because we don't have a current financial agreement or anything like that. And I'm not really sure about what the financial agreement even is. So we're trying to go pro se there as well. And it makes me very anxious thinking about it because I can't file anything in the other case. And with him being non-responsive, I'm very worried about these deadlines.
Right. Well, I mean, so first of all, I can't give you legal advice, right? Because I'm not your lawyer. So I'm sort of limited in what I can say to you. What I'll say first is that any issue, if you have a concern that there's somebody who's signed on to be your lawyer right now in Judge Donato's case, and he's not actually serving as your lawyer, or you're trying to get him to withdraw, you need to take that up with Judge Donato, right? Because that's his case. It's not my case. There's nothing I can do about it. And you know, there has to be a way to tee that issue up in front of Judge Donato. You know, and have you had any communication with our pro se help desk?
Limited communication with that.
You might want to sort of present this problem to the pro se help desk and ask them for their guidance procedurally on how to tee it up in front of Judge Donato. I mean, a lot of times I'll just get a letter from a pro se plaintiff asking for some sort of relief, and we just act on it because they're pro se. We don't make them file a motion or meet a deadline or whatever. So maybe it's as simple as sending a letter to him. But I would, I can't give you legal advice. I would recommend that you talk to the pro se help desk, present this situation to them, and see if they have any guidance for you.
Understood. Thank you, Your Honor.
Okay, what else? Anything else from anybody?
Nothing else from Google and YouTube, Your Honor. Thank you for sorting and navigating through this issue.
Nothing further from plaintiffs. Thank you, Your Honor. We appreciate it and apologize for the confusion that arose here through the various procedural problems.
Stay safe in Florida.